Every Tuesday, we do bring in immigration updates. Emily, what do we have today to discuss?
Yeah, today we want to talk about the Commerce Secretary and the Florida governor, both recently talking about H-1B visas and calling them a scam. What does that mean for H-1B restrictions possible? What is the power of these two individuals to make changes to H-1Bs? Should we take it with a grain of salt? How serious should we take it? We'll also talk about being laid off when you're on an H-1B. We're seeing this continue to happen, and a lot of people are questioning whether the options are still the same. Can we still file a B2 or an H4? Are there any changes in that? Mainly because the page that discussed that option on the USCIS website has been archived. Have we noticed any changes to that? Is it still an option? We're also seeing again problems with H4 and H4 EAD renewals and the delays caused by long processing time, the lack of bundling. Is it possible to expedite these in order to get the H4 EAD on time and avoid losing work authorization? And then finally, we'll discuss how USCIS is detecting fraud in H-1B petitions and things that companies should not be doing so you can ensure that you are not falling into that trap and getting caught in any of those scams.
Emily, I see that overall the administration is totally divided on the H-1B from the beginning of this administration. We have this kind of mega people who are opposing the H-1B, and then we have some moderates who are, supporting this H-1Bs. We have seen the Commerce Secretary, who is part of the cabinet of the Trump administration, calling it as a scam. But I've also seen the discussion between the Fox News and the Florida governor. Um, Florida is not a technology-oriented company as such to a greater extent. Um, and even Florida governor calling it as a scam, but he's kind of reiterating the word what the Fox News personality said it though. They also called that they're issuing 400 visas last year. I don't know where they got the stats from. That the 400,000 H-1Bs were been issued in 2024, which is not true at all. Can you elaborate more on what their comments, what do they mean, according to you?
Yeah, so for Ron DeSantis, he mentioned these on Fox News. We can expect Fox News is not going to be pro-immigration. And many times people go on these shows and they reiterate what the host is asking them and are playing to their base when they're on those kind of shows. So number one thing to know is he's a governor. He has zero power over anything to do with H-1Bs. So he can't change the law. He cannot increase restrictions. I mean, he can talk about it, but he has zero actual power. And then the Commerce Secretary is saying that H-1B is a scam. At the same time, he's promoting the gold card, which is a scam as of this moment. There is not one gold card out there, but how long ago did he say he'll have it up and ready in 2 weeks, and he's already sold what, 35 of them? All of that's a scam. Fake news. So neither of these people have any kind of power to change anything to do with immigration. I think Lutnick was talking about the proposed regulation to change the H-1B lottery to make it a wage-based system. Even that, if they go through the regulatory process, it's not been published yet, it's going to have a problem because the statute says first come, first served, first in, first out. How can you distribute visas in the order received if you're doing it based on anything other than the order received? So you need Congress to make that change, and I don't see Congress doing that anytime soon. So I take all of what they're saying with a grain of salt. We've heard these kind of things before. There was a big social media stir about them in December that happened, and we're still in the same boat. Yes, there are additional scrutiny on H-1B. Yes, it's going to keep getting more difficult before it gets easier, but I don't think I'm too concerned about what these two have to say about H-1Bs.
Emily, the people who gets laid off in H-1B, that we have said that there are options. If they have an H-4, we definitely want them to move to H-4 option. There's always a F-1 option, and if they want to go back to school, which not many people will opt for because it's a more expensive option, then we have this USCIS website where they publish that if you are laid off, you can move into B2 so that even if the B2 is pending, then you can apply for the change of status to H-1B later on, and you can move back to the H-1B without any problem. That was the USCIS website said. Now that website is that particular link has been archived right now. What are the suggestions if they don't have the H4 option? And do you still suggest people moving on to B2 if they don't have a job? Of course, they do have a 60-day grace period. We already covered on the NTA, where some people were being issued in the months of June and July, but we haven't seen any NTS issued in the month of August. We haven't seen anything that is coming in September. Where some people will be in issued. In particularly, I told that I would not be taking very serious consideration of any NTA chances at this point of time. But in general, Emily, do you still suggest people to move on to B2 if they don't have an H4 option?
I do. Even though that page was archived, it does not suggest, or we've not seen anything to suggest that they're not following it still. So we are still filing change of status to B2. We are still getting those approved. We're still getting the change of status back to H-1B approved later. We've not really seen any change in adjudication of these applications due to the fact that that web page was archived. So as of now, it is still a viable option, and I would continue using it in the current environment.
Right? And we still have seen a lot of people who have applied for B2, their B2 got approved, and afterwards their H-1B change of status got approved. There are some rare cases we are seeing, not all the cases, some cases where we are seeing an RFE when the B2 is still pending. But a majority of these cases, when the response has been done properly, their H-1B is getting approved with the I-94. So we strongly recommend to consider the option of the B2 if you lose the job, even under the current circumstances. If you need any help, you can always contact us. We can tell you how to file. We'll draft the letter. I'll go through the form and make sure everything has been filed all right. You can do the B2. We do that for hundreds of people, have no issues at any point of time. Um, Emily, on the H4 plus EAD options, those people who are applying for H4 plus EAD extensions, we are particularly speaking about. Now, if let's say, for example, main applicants, H1B is expiring in December of 2025. And right now, they are filing H1B and H4 and EAD together. I want to run through a couple of scenarios how you can resolve it. If the H1, H4, and EAD are approved together, we don't have any problem. We can continue working, so no problem for the H4 and EAD. Now, if the H4 and EAD is not approved, what do you suggest, Emily, at that point of time?
Yeah, I think the first thing to look at is how do we qualify for the automatic extension in case that EAD doesn't get approved by December 2025 when it's expiring. And you do that by getting an H4 extension beyond December 2026 in your example. Um, Assuming that the I-539 is not going to be approved in time, we need to look at Plan B, which is going to be possibly traveling to Mexico, having a margarita, coming back and showing the H-1B extension approval, the valid H-4 visa stamp that has not yet expired, and the valid H-4 I-94 that is not yet expired. This has to be done before the current H-4 expires. And we are still seeing people are being given the H-4 I-94 to match the H-1B approval notice. Once you have that, now you qualify for the automatic extension of your EAD for 540 days, which should be enough time for you to get the actual EAD approval.
In case where my passport visa is not stamped in the H4, how can I go to Mexico? You said my passport visa is valid until December 2025. No, it's not. I only have I-94 until December 2025.
So now we're looking at the same idea, but using automatic revalidation to revive that visa and make it valid on your return trip into the US. And you do that based on the fact that you have an H-4 I-94 that has not yet expired. So again, this has to be done before December 2026 in this example, but you can travel
2025,
with
yeah.
2025, yeah.
Yeah.
You can travel to Canada or Mexico with an expired visa stamp as long as you have a valid I-94 to return on. And then you will be able to come back in. And when you show your spouse's H-1B approval that's extended beyond 2025, you normally will get that I-94 valid for your H-4 beyond 2025 to match the H-1B. So it's still possible.
What is this automatic revalidation? Even if I don't have the visa stamped in the passport for the H-4, I can still come back. Is that what you said, Emily?
Yes, only if you're traveling to Canada or Mexico, only if your trip is for less than 30 days, and only if you have not gone for visa stamping in Canada or Mexico, and you have a valid I-94 that is not expired to return back to. Now, if your visa has expired, you might have to get a visa to go to Canada or Mexico, but coming back, they revalidate your expired visa and treat it as if it has not expired on the day you're entering.
One caveat, guys, if you want to go to Canada or Mexico, we strongly recommend that you fly, do not drive. And we also recommend that you get a Mexican visa or Canadian visa before you go. Mexican visas are very fast to get it, easy to get it, so you can achieve them very easily. We have had a lot of people applying, had no difficulties in getting. So these are the ways to, is there any other solution, Emily? I am now contacting you in January of 2026. My I-94 expired. My passport visa is no longer there. Is there any other way to expedite?
There's options. Some are better than others. So what we used to be able to do is submit an expedite request. So you call customer service, you explain to them you're about to lose your job, especially if you're in healthcare or have an important job, they might consider expediting the H-4 EAD. Under the Trump administration, that's practically useless. They're not expediting anything. We used to be able to reach out to your congressman's office and say, hey, I'm facing trouble with the federal government agency. USCIS is delaying my EAD application. I'm going to lose my job. They would then reach out to USCIS. Well, that's practically not working anymore. And then we used to be able to reach out to the Ombudsman Office of USCIS, and they would get involved when they were seeing these constant delays in EAD renewals. The Ombudsman is now just a one-person office that is practically useless for anyone facing that issue. So that leaves two other options. Number one, if you can get a visa interview appointment, you could potentially travel to your home country, get your H-4 stamped based on your spouse's already approved H-1B, come back, and now you again qualify for the auto extension because you'll get a new I-94 that way. Of course, there's the risk that your H-4 visa might be delayed when you go for stamping. And we also have the new rule that you have to be interviewed as of today. They're no longer accepting Dropbox. And if you're taking your kids with you, your kids have to be interviewed, even if they are babies and infants and toddlers. So that's not a great option, but it is an option if you can get an appointment. Last option is litigation. We did a lot of that during the prior Trump administration. That is what eventually led to the bundling requirement settlement agreement. Of course, that settlement has expired, so we're back to kind of square one on that. But litigation can work to deal with these unreasonable delays. It's expensive, $5,000 to $7,000 to get your EAD. But it's definitely something you can try to avoid by filing early, filing in premium processing so that you don't have to go down that path. But there are still options even if your current I-94 is already expired.
We are noticing a lot of fraud issues not a lot, I would say that a fraud issues with regards to in-house projects of the consulting companies. And even if you move out of that company at this point of time, let's say company A files the H-1B in 2024, and now you are moved to company B, there is a chance that the company B's H-1B can be denied because company A has filed a H-1B, which is an in-house project. Emily, how do the USCIS, how do they find it's a fraudulent application though? And is that going to be only when I'm working with this particular company, or can it affect me in any other way?
I think the easiest way for them to figure it out is usually through the site visit, FDNS, that's Fraud Detection National Security Directorate. They'll visit the company and see that there's no office there. How are you working on this in-house project if there's no computers for you to work on? They've never purchased any software licenses. They have no customers for this in-house project. So it's pretty easy for them to see that way. They're also doing a site visit at the employee's residence if that's where they're working from home on this so-called project. They're doing it even after the H-1B has been approved, even years after the fact, after you've already left the company. But they also have access to a lot of information online. USCIS uses Vibe, Dun & Bradstreet information. They can see who owns the company, who the registered agents are for the company. They can see what attorneys are representing the company. They can see what address they're listing as the work site for all of their LCAs. All of that information can easily be cross-referenced with other petition filings and documents, and they can see that some of the explanations for these in-house projects have been stolen from other actual legitimate projects. It's very easy in this day and age for a paper trail to be made because everything's digital. And so it does not take much for them to find out that the project isn't actually existing.
Anything else, Emily, before we go for the questions?
Nope, I think we can move on to questions.
AJ is asking with regards to the wage-based H-1B applications. Is there any update on it? Right now, wage-based applications are not there. However, the Trump administration is wanting to bring them back, bring it in 2026 lottery. That is, we are going to start filing in, 2027 fiscal year, which we're going to start filing in March of 2026. They're wanting to bring, but as Emily has pointed out, that the law is very clear. It's first come and first need to be selected. That's how it is. So if they are doing the wage-based, we believe that it is not legal. They should change it in the law, not in the regulations, which is through the Congress, which Congress doesn't intend to pass at this point of time. So we'll see how that goes on through the litigation. When and if they issue the proposed regulations, at that point of time, we can comment, and we'll see how they're going to act on it.
Sai says, I have my I-140 approved from 10 years ago as a software engineer. Now, if I need to change to a different company, I'm going to have totally different job duties. Is that going to be a problem for my new I-140? No, not at all. Your new I-140 is going to be based on a new labor certification. That's going to be based on your new job. It has no reference to your old job at all. So it's based completely on what is the new job you're being offered, what's the education required, what's the experience required. Regardless of how same or different the jobs are, doesn't matter when it comes to retaining your priority date. That old job has no relevance to the new I-140 petition after the new labor certification.
Rifat has this question. He has a DUI back in 2017. It expunged in 2021. I've been maintaining H-1B since 2018, waiting for the green card interview. According to 245A, should there be an issue on this one? That's a question he has. Well, you will have to provide the information at the time when you file the 485 application. If you have not provided, we definitely want you to amend the I-485 application. There is a good chance you will be interviewed at the 485 application. You'll have to take the entire documentation of the DUI, and you have to explain the things there. Have we seen anybody who has one DUI with no physical injuries to any people? Have we seen any, no accidents, let's say just a DUI? Has there been any issue with people not getting the green card? No, we have not seen it. People have been getting the green card who have had a DUI with no accidents.
Vikas says that recently USCIS has started giving a NOID, notice of intent to deny, for H-1B extensions, citing signatures with the issues with the signatures. Are asking for the wet signature. Yes, that is a new trend we're seeing. So prior to COVID, everything we would file with USCIS needed original wet ink signatures. Once COVID came around, they changed their policy and said that you can provide scanned copies of the original wet ink signature as long as you keep the wet ink signature on file in case we ask for it later. Now, that COVID policy changed later to just a policy that we will accept a copy of a wet ink signature. Their current policy manual does not say anything about keeping a copy of the original wet ink signature. Doesn't say anything about them being able to request that in a NOID or an RFE. And on top of that, the statute and the regulation only says that the signature needs to be handwritten. It does not specify that it has to be wet ink at all, and that it can't be a person who is signing something digitally as their handwritten signature. So we are aware of this. We have responded back to some of these and have been able to get approvals. We're aware of people that have seen denials. So another reason why it's important to file your extensions early, so that if you get that denial, you turn around and file it again. No harm, no foul, other than the additional cost. The big issue is cap cases, because you can only file that till June 30th. If your cap case gets denied because of the signature issue, you don't have the opportunity to refile it. You have to file an appeal or litigate. We are looking into litigating these cases because it is completely not in line with what the statute says or the actual policy manual. They're claiming that they can request, it's evidence that they can request, but when they're talking about evidence, they're talking about the supporting documents. Like if you submitted a copy of a birth certificate for your child for their H-4 application, USCIS does have the authority to request the original. That's what they're basing this on. A signature is not really the same as an actual piece of evidence. So I don't think they'll be able to stand on this for very long. But yeah, it is quite a mess for a number of companies right now.
Kishore is asking this question. Do you recommend premium processing for H-1B? And this will be bundled H-4 and EAD together. Is the premium processing available for H-4 and EAD? H-4 EAD does not have a premium processing. The same premium processing works most of the time, but not all the time for the H-4 plus EAD. We strongly recommend to get the result of the H-1B before your I-94 expires. Let's say, for example, your H-1B is expiring in December of 2025, and you are filing an extension right now. And if you get a result before December 2025, we really appreciate it. Why we don't want you to wait until January to get a result is, if by any chance you get a denial, then at that point of time, you'll have to leave the country and come back into United States. But if you get the result by, let's say, before December, if by any chance you get a denial, you can refile the H-1B extension one more time. So that gives an extra time. That's the reason we want premium processing for the H-1B extensions.
Ganesh says, I'm looking to travel to India, currently on F1 STEM OPT, but the F1 visa stamp has expired. Is it advisable to renew the visa stamp in the current environment? No, it is
No.
not. You should not travel in that situation. No, 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 no. Bad idea.
Is it true that you can only get the visa stamp in your own country? Not true, not true. No, you can still get in a third country at this point of time. They haven't changed the policy yet.
Lucky Luck says, is it advisable to apply for the I-140 in premium processing? It depends on the type of I-140. If it's a typical perm-based EB2 or EB3 I-140, I have no issues filing those in premium processing, do it all the time. Not seeing any weird things in those adjudication. If you're talking about EB1A, EB1C, NIW, Not a fan of premium processing for those right now. It tends to just trigger an RFE that looks like they didn't read anything that you submitted. So you're having to do a lot of double work to provide the response to that, and you're not getting the benefit of a fast result because of it.
Fawad Khan has this question. Do you see any problem in people traveling GCEAD? Absolutely, I do see. Well, you can't travel in GCEAD. It should be an advanced parole, though. The reason we want very careful is that when you apply for GCEAD and advanced parole, sometimes they issue GCEAD and advanced parole together. Sometimes they don't. And I've seen some people, they get the GCEAD, whoops, I'm going to travel right now. They travel and get stuck outside the country now. At the same time, if you have an advanced parole, which is valid, we have not seen any problem whatsoever at all in the people who are traveling in advanced parole. Absolutely not a problem. Questions coming on. The other issue is that if I have a visa stamping, do I have any problem in traveling? We haven't seen much problems for the people who already have the visa stamping to travel uh, outside the United States. No, we haven't seen any problem.
Naren says he's got the H-1B already approved from January 2026 to 2029. But he's traveling in September of 2025 to apply for a new visa stamp. Will the visa be valid only from January 2026? Can I re-enter in October 2025? So the approval notice is in the future. Yes, you can still get the visa stamp now, as long as you have the continuing petition validity from now through January 2029. Your visa stamp is likely going to expire before January 2029 because the reciprocity table only allows them to issue it, I think, now for 35 months, not the total amount of time that you have H-1B status for. But yes, it's in the FAM that allows you to do that when you have continuing validity between two petition approvals.
Does having a child delay the F2A processing? This is green card holder filing for the wife. No, we haven't seen that actually. In fact, there is a small procedure. At the most, it may delay by about 1 week. Not even that. So, no, the child should not delay the F2A process. It's just we request um, processing center to issue another fee structure where we can pay for the kid, and we are having no problem, none whatsoever at all, to add the kid. So you can have a kid on F2 while the F2A processing is getting done for your wife.
Zoomer says they had an agency file the EB3 I-140 for them as a nurse. That I-140 was approved 2 years ago, and the priority date's now current. Can the agency still file the adjustment of status if I don't work for them now? Yes, if the job offer that they made to you is still open for you when you get your green card. So the whole green card process is not based on current employment, it's based on the future job that you will move into when you get your green card. So if they're still holding that future job open for you, you can still complete the process even though you're not working for them now.
I have a GCEAD and H-1B active. If I get laid off, can I start using the GCEAD? Absolutely, you can. I don't see any problem at all. Even if you are the prime applicant, even if you are a dependent applicant, yeah, in either of those situations, we don't see. But your new job, if you are the primary applicant, should be in the similar profession in which you're already working. Let's say if you're an IT professional, you can be working only in IT profession. You can't become a manager of a restaurant or a lawyer like me. Um, uh, but within the same profession, you can use the GCE if you are primary applicant.
Kishore says, do you recommend H-1B premium processing for an extension? And is there premium processing available for the H-4 and H-4 EAD extension as well? Yes, I do recommend filing an H-1B extension in premium processing, especially if you're not filing it at least right at the 6-month mark before your current status expires. The most important thing is you want to get the decision before your current H-1B expires, and premium processing allows you to do that. I don't see a lot of negative results of premium processing, like increased RFEs or weird RFEs. I think that's kind of been limited to those I-140 categories I mentioned earlier. But there is no premium processing for H-4 or H-4 EAD. Now, sometimes they do still bundle them together and approve all three together in premium. Sometimes they separate the H-4 and H-4 EAD and approve them a few days to a few weeks later. Sometimes they're completely separated and it takes months for the H-4 and H-4 EAD to be approved, even though the H-1 was approved in premium. And that's why that travel option may be your best option.
Ravi has been following us. He moved from L1B to L1A, nice. And then he got his I-140 approved in EB1C, nice. His prior date is September 2023. Oops. So he's asking that he already moved to H1 and H4, which is a good option. He did it because he don't know when the prior date is going to be current. Since you have an I-140 approval, you can keep on extending H-1B, but there is a limit on L1A of 7 years. After that, you can't. So then he now he needs stamps. Should I travel to India for the same? Why do you need stamping? You already got the H-1B approval. You already got the H-4 approval. You already got the EAD. You can continue staying in the country. You can continue working in the country. Absolutely no problem. Why do you need to go for stamping? Everything is going smoothly. That's my recommendation. No, 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 no. Don't go for stamping. The issue is that what do you expect the priority date for EB1? I hope I'm wrong, but I see a lot of people who are cutting the lines in EB1C. Now you may ask, well, how do they cut the lines? Because people who are in EB2 and EB3, they are now applying in EB1As and EB1Cs, and in some cases EB1Bs and getting them approved. Their priority date may be earlier than 2023. That's the reason why it's very hard to predict the movements of the EB1s right now. So I can't tell it, but since you're on H1B, that's a very good thing that you did it because you can stay on H1B for however long you want to.
Janish says, can we not bundle the H-4 EAD application with the renewal of the H-1B? Yeah, so I think you're using bundle differently from what I would. So you can concurrently file an H-1, an H-4, and H-4 EAD, meaning you file all three together. That is still an option. When I'm referring to bundling, it's talking about USCIS bundling them together to actually approve them together. They are not required to do that anymore. So sometimes they'll only approve the H-1B, even though the H-4 and H-4 EAD were filed concurrently along with it. They're going to different service centers even, and those are taking longer than the H-1B.
Second.
Dallas says, is the perm processing speed improving? No, it continues to get worse. I think we're close to 500 days now for perms.
Vivek Jain is asking this question. When do you expect the domestic visa stamping happening? Definitely not when the Trump administration is there. I'm not expecting because this administration is not wanting to make anything easy for the non-immigrants, anything easy for the immigration to adjudicate the application. So I'm not expecting while the Trump is in power. Ravi Shankar wants to travel to India, and so that's why he needs to get the stamping. Well, uh, if you can avoid, please avoid. If not, then you'll have to take a risk. That's all I can tell. If you can avoid, please, because since you're EB1C, it's not worth it changing the company. If I would have suggested to change the company. Since you're an EB1C, you can't change the company right now. If you can avoid traveling to India, that's better. Otherwise, you take the risk.
Jinkia says, my wife's H-1B expires in February. Can she continue working until then if we apply for an H-4 change of status in an EAD now? And then what happens beyond February 2026 if we don't get the approval? Yes, she can keep working. She's still in H-1B status. Even though you filed a change of status to H-4, you're not in H-4 yet. It's pending. I don't know why there's some companies that are telling people that as soon as you file the H-4, you have to stop working. Not the case. But if the H-4 and H-4 EAD are both not approved by February 2026 when her H-1B is expiring, then she either needs to file an H-1B extension or stop working until the H-4 and H-4 EAD get approved.
If I change my employer after EB1B I-140 is approved a year ago, can I use that as my priority date for another EB1B? Absolutely, you can. Now, you cannot use EB1B of company A to file the adjustment of status with company B because company A has to cooperate. But when company B files the EB1B again, you can use the company A's priority date. Absolutely not a problem. This question is from RK from YouTube. One second. Fawad Khan has this question. His daughter is turning 18 and she has a H4, and now she has a GCEAD. And can she start using EAD? Does she need to inform the USCIS? No, if she already has a GCEAD, I'm assuming that she's already protected under the Child Service Protection Act. She can start using EAD. Absolutely. She doesn't have to inform USCIS. She just can start using EAD. No problem with it.
Prachi says, we filed my minor daughter's I-539 to extend her H-4 back in April 2025 and still no response yet. Is this normal? Yes, unfortunately it is. When the H-4 is filed by itself, it can take anywhere from 4 to 12 months. There's no rhyme or reason to it.
Is it Shesha Kohli has this question? I'm an H-1B. Is it safe to travel to India and get stamped? No, not at all. Not in the Trump administration. Compared to F1, probably H1 is a better thing, definitely, but it's not safe at all right now under the current circumstances. We see a lot of 221Gs, a lot of problems for getting a lot of people getting stuck outside the country, though. We strongly recommend to avoid traveling outside the country to get the stamping right now.
Cool US says, I have an approved EB2 I-140. I'm planning to file an I-140 and EB3 with the same company. Should I file that I-140 in premium along with the 485 concurrently or in regular when the filing date becomes current? I'm going to say none of the above. um, Number one, you can't file the EB3 I-140 in premium because you are reusing the old labor certification and they have to pull it from your old file. So for that reason, they won't accept premium processing on the initial filing. You could potentially upgrade to premium a few weeks after filing, like when you get the receipt notice, and we do that all the time. I would suggest filing that I-140 in EB3, upgrading it to premium processing, getting it approved, and then filing the 485 separately. We see a lot of weird hiccups happen when you file the I-140 and I-485 concurrently, because those I-140 and 485, for some reason, everything gets routed to the Texas Service Center or the Nebraska Service Center, and then they keep it until the I-140 gets approved, which may take 6 months to a year later. And then they'll eventually transfer the 485 back to the National Benefit Center where most of them go. So if you want a faster processing of your 485, we have found if you file the 485 as a standalone based on an approved I-140, it goes straight to the National Benefit Center and generally is processed faster.
Um, Pavid has this question. He has income derived from a company. So I don't know whether you were actively participating in the company or you're not actively participating in the company, though. So if you're actively participating in the company, definitely I want you to consult a lawyer. If you're not actively participating in the company, you are just a shareholder of the company, then definitely not a violation, none whatsoever at all. Uh, 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 if let's say, for example, if you own a Microsoft stock, that means that you are an owner of the company. You're not actively participating in Microsoft company. You're not. So in that case, absolutely not a problem. But if you're actively participating in any company, any format if you're an H-1B, definitely I want you to contact an immigration lawyer.
Vivek and a couple other people have asked for an update on domestic visa stamping. Is there any hope for that in the near future? I think that is out the window. I would not expect that to happen anytime. And you can obviously, when the State Department goes from interview waivers are available for most people, we're not going to interview kids or senior citizens, to now we interview everyone. Domestic visa stamping does not involve an interview. Of course, they want to interview everyone. They want to kick everybody out and leave them stuck abroad. That's how they get everybody out of the country. You can't get them out of the country if you do domestic visa renewals. So I don't see that any plan for that to move forward anytime in the current administration.
Can we do a AVR, automatic revalidation, after the H4 I-94 expires? Absolutely not.
No.
Um, second. Jagannath has this question that I have my EAD and advanced parole, both of them filed, but I only got the EAD approval. This is for the 485 application. The advanced parole is not yet approved. How to expedite it? The only way, that practical way that we can think about, is filing a lawsuit, but that still will take 60 days, 60 plus days at least. You can see between 60 and 70 days is a typical timing to get a result. You can contact Stephen Brown in our office.
All right, we have a question from Gokul, Sesha, Suresh, and multiple other people with varying themes of, I need to go for stamping. Can I travel? I have a good work status. I want to visit my parents. My parents have poor health. I need to go for this. I'm a business leader. I need to go for that. No, it is not safe to travel if you need a visa stamp. You are going to get stuck there. The whole point of eliminating Dropbox is to require everybody to go for visa interviews. When they interview everybody, it slows down the whole system. So not only is there going to be delay, but then they're also going to be doing administrative processing for more people. That's going to take forever. You're going to end up losing the job. No, it is, regardless of your reason, it is not safe to travel if you need visa stamping right now.
It's like going to the heart doctor and you have a heart disease, and you're just telling that I'm going to eat fried chicken in the breakfast, fried chicken in the lunch, fried chicken in the evening snack, and fried chicken in the dinner. What's the response from the heart doctor will be? I mean,
Right, exactly.
same response you will get it from us guys.
Guitar Cover says, can you retain your EB3 priority date if you go for EB5? No, you cannot. That only works between EB1, 2, and 3.
Oh, Zay has this question. Interesting. Is it advisable to file a STEM OPT after filing a 485 recently? Initial OPT expires this month. 485, 485 filed 1 week ago. Yeah, you can. I don't see any problem with it, because you get an automatic extension for 180 days. Of course, it's 180 days, yeah, at least 180 days. So definitely filing filing an EAD is advisable. Filing a STEM extension is advisable.
Nitin wants to know how long H-1B extensions are taking in normal processing these days. I would say anywhere from 2 to 6 months if there's no request for evidence, could take longer than that. So if you're planning to file it in regular processing, do it at the 6-month mark. Don't wait till the end and then file it in normal processing and let your I-94 expire and then 6 months later end up with a denial.
Deepak has this question. Is it safe to travel on advance parole if the H-1B needs stamping. Now, if you have an advanced parole, we strongly recommend do not go for H-1B stamping. Come back in advanced parole. Your H-1B is still valid once you come back. You can amend it, you can extend it, you can change to a different company and file a change of employer on the H-1B. So no need whatsoever at all if you have an advanced parole to go for stamping.
Alan says, if I already went through administrative processing when I went for my H-1B stamping, will they ask me again to go through administrative processing since I haven't traveled back in a while? They absolutely can. Every single visa application stands on its own. They can ask you the same question every single time you go for stamping. They can ask you for the same documents every single time. They can put you in administrative processing every single time. Just because you went through it once and were successful does not mean they won't do it again, and it doesn't mean the next time will be successful.
Any trends on the adjudications of the compelling circumstances CAD filings? We haven't seen any denials for the compelling circumstances CADs, though. But however, I just want to note people that once you move into compelling circumstances CAD, for you move out of the compelling circumstances CAD, you can't convert from compelling circumstances CAD to H-1B. You will have to go outside the country and get the stamping. That's where the problem comes in. If you move into B2, though, you can move back into H-1B without going outside the country. But for compelling circumstances CAD, you have to go outside. But yeah, to answer your question, Mohan, we are not seeing any problem in getting the compelling circumstances CAD approval.
Let's see, where did that one go? Favad says, given the amount of changes we see in immigration, do you think the October visa bulletin will have any movement in EB2, any spillovers coming? I do think we're going to see some spillover this year from family-based. I think there was a report recently by the Naseekan Center that suggested that they issued 20% fewer family-based green cards than last year compared to last year. And so that might mean that they didn't hit the family-based limit, which means those leftovers go to employment-based next year. However, if we're talking about EB2 India, it's going to have very little impact. We already know from the prior inventory, there were 48,000 485s already pending that have priority dates before January 2015. How long does it take to get through 48,000 485s? About 8 years if you're born in India. So it's going to be 2033 potentially before we see any real movement beyond where we already were in 2020.
Sesha Kohli has this question that if I have a valid I-94, is it advisable to go on automatic revalidation to go to Canada? And Canada, she has a Canadian visa, and then can she come back using the valid I-94? Absolutely not a problem. Absolutely not a problem. And people have questions: can I drive or can I fly? If you have the valid I-94 and you want we don't see any problem in driving. Especially when we want the I-94 to be extended based on your spouse H-1B or L-1, that's when we actually want you to fly instead of drive. But for just automatic revalidation, you just want to visit Canada, you want to come back, and you don't want to do any margarita switch or you don't want to do anything, then definitely driving is fine.
Sridhar says, how many minimum citations are required to get into EB1A from EB2? And should you file in premium if you have 50 citations? There is no minimum number because citations are not a specific requirement of EB1A. They're one of the methods that you could choose to meet one of the criteria. But they're not the only method. So you could get an EB1A without any citations. On top of that, it's not the number of citations that matters, it's the quality of those citations. There are services out there that are multiplying citations somehow with whatever they're doing. And USCIS is caught on to that and they see that. They want to see what the quality of the citations are, what journals have cited your work. What is the readership of those journals? Is it a well-known, respected journal? So having 50 citations is not anything that anyone can make a decision on, but as far as premium processing, I really don't recommend premium processing for EB1A. Maybe upgrade later after a few months, but not in the initial filing. It's just triggering RFEs.
A question from Janish Patel. Moving from H-1B to GCA EAD, can I work non-technical jobs? Most probably is GCEAD. If you're the primary applicant, and if your primary job was in a technical, when you say technical, I mean to say IT job, can you move on to non-technical jobs? For example, can you work as a restaurant manager? Absolutely not. That's going to risk. Now, if by keeping the main job, if you want to do a side stunt part-time, that may be fine. But leaving your main job and doing as a, let's say, for example, restaurant manager from IT job, absolutely not allowed.
Dragon Warrior says, my wife's EAD expires in September 2026, but the I-94 expires May 2026 due to the passport expiration. I'll be filing my H-1 extension in April 2026. If I filed H-1, H-4, H-4 EAD in April, can she work until September? No. This is like those trains geometry questions from middle school, I feel like. No, she doesn't qualify for the automatic extension because her I-94 expires in May. The only thing that gives her the automatic extension to keep working is her H-4 being extended.
When people
So
are repeated,
pending H. Go ahead.
no, you go. When people are up asking the repeated questions, guys, it's because the question is not properly phrased. It's very hard for us to answer. This question is coming from Joshna. She's been repeatedly copying and pasting. Please, we have a team that deletes all that information, though. But anyway, coming to the point, you are saying that your L1B extension is in progress. Can you file L1A and EB1? First of all, we need to know when your current L1B is expiring. That we don't have an answer for it. So if your current L1B has not expired, then definitely applying for L1A and EB1C, definitely you can do it. If the current L1B has already expired and you are in extension is still in process, it may be a risky process to convert into L1A at that point of time, because I would rather want to get an L1B extension already approved. So crucial question here is that, is your current L1B already expired or is it expiring? We don't have the answer. So when we're not responding to your question after you repeatedly putting, please let us know in the question itself that when is your H1B, when you're, rephrase the question. Now she's telling that it's expiring of the year end, which is 2025. In that case, I don't see any problem in converting into L1A and also filing an EB1C.
Let's see here. Favad has a follow-up question. He's one of the people stuck in the backlog that I was talking about it taking 8 years to get through. And he says, my priority date's June 2014. Are you still saying 8 years? Well, let me say this. So as I mentioned, there's 48,000 pending. That's going to take 8 years to get through those. And those go up to January 2015. Now, if yours is before January 2015, what do we know? We know that there's 4,000 pending before January 2013. So you've got 4,000 people in front of you already. That's to get to January 2013. We have another 17,000 to get through 2013. So now that's 21,000 people in front of you. And then we've got to get to June 2014. I can tell you it's going to, so probably going to be 3 years to get through all of 2013, another year to get just to April 2014, and then we'll see how fast it gets to June 2014. But it's going to be at least 4 years for sure.
Safan Ansari, he has speeding tickets, no arrest, no fingerprints, no court appearances, and he resolved all those things. He paid the traffic tickets. I'm assuming that all these traffic tickets are minor traffic tickets and does not involve any accidents or does not involve DUI, and involves in traffic ticket payment for each ticket is less than $500. You don't have to disclose that information on DS-160.
Month says my I-140 with my previous employer was recently denied due to company financial statements. Is it worth refiling that I-140 using the same perm? Well, you mentioned it's a previous employer, so it may not be useful if you already have a priority date from another previous employer. But if this is your first I-140, it may be worth refiling to lock in your priority date, even though you're no longer with that company. Of course, you need the company to be willing to do that, number one. And number two, it depends on the reason for the denial. Is it because they submitted financial statements for the most recent year because they didn't have the tax returns yet, and now they have the tax returns and the tax returns look good? Then yeah, you could probably refile. But if the numbers still look bad and you don't have any pay statements from that time period because you weren't working there, it's not going to make the numbers look any better, unless they can make an argument that that was a particularly unusual year and that the years prior to that were good years and the year after that was a good year and it's just one bad year. There's a case law about that matter of Senagawa, if I recall correctly, that could be used. So it really just depends on what the financials look like.
Um, Question, can we use the college certificate as a birth proof as a secondary evidence? The primary evidence for the birth certificate should be birth certificate or non-availability certificate plus two affidavits. This is a must. Now, after you have it, if you want to have an additional proof of those things, then definitely you can go for college certificate, school certificate. You can go to for Aadhaar card, PAN card, ration card, election card, uh, hospital records. All those things can be considered as a secondary. But you need to have the primary. If you don't have the primary, either birth certificate or non-availability certificate, you are going to get the 485 denied. That is a new rule right now. If you don't have a birth certificate or non-availability plus two affidavits, you are going to get the 485 denied.
Nirvana says, I got my I-140 approved via EB1 self-petition. Is it possible to get the AOS done by a different attorney or from my company? Yes, it is. You do not have to stick with the same attorney that filed the I-140 in order to file the 485. No issues there at all.
Um,
Rakesh says, can we take a promotion if have an EB2 I-140 approved and 80% of the job responsibilities will be the same? Do we need to go through the I-140 process again? Generally, no. A normal career progression doesn't always mean you need a new labor certification and new I-140. On top of that, what is your priority date? Is it going to be 20 years before you're ready to file the 485? If that's the case, how many promotions do you think you're going to get over the next 20 years? And what good does it do you to go through the process again now? You don't need to go through it again until your priority date is about to be current. So you don't need to file even if your promotion meant that you needed a new labor and therefore new I-140. You don't have to do it right now, especially if you're not going to be filing the 485 anytime soon. But you do need to monitor and guess when it will be close to becoming current and file 2 years before that so that you get it approved in time.
Josna has this question that if you convert into F1, H4 to F1, can you convert back into H4 at any point of time? Absolutely, you can. No problem with it.
Deb says my wife's current H-1B expires in June 2026. Her perm is currently in process. She's in the 6th year of H-1B. Does her H-1B get extended for another year when she applies for the extension? Depends on when her perm was filed and when her 6-year limit is. So if her 6-year limit is June 2026, but she didn't file the perm until July 2025, she's not eligible. She needs to file the perm 365 days before the 6-year limit is going to be reached, or get the perm approved and the I-140 approved to get a 3-year extension. But if she filed her perm in May 2025 and it's still pending, she could file her H-1B extension in December, 6 months early, and get an extra year based on however, maxing out the 6-year limit plus the 7th year extension based on the perm being filed 365 days before the 6-year limit is hit.
Um, I have an approved H-1B. My son is a U.S. citizen, and my spouse is an H-4 approved, and Kavya is an H-1B. Sorry, this person is an H-1B. The spouse is an H-4, and the child is a U.S. citizen. I've not been to India for 6 years. Is it recommended for me to travel to India? Absolutely not. But if your dad has a Ferrari car waiting for you and a big villa there and a couple of $1 million for you, please, you can go ahead there. If not, I mean, if you're a common, just like Tom, Dick, and Harry, your parents are, and then definitely I don't recommend that you travel. That's strictly my recommendation.
All right, well, I think we are out of time for today. Thanks everyone for joining us. Remember that you can sign up for our newsletter by going to our website, rnlawgroup.com. We do update our website every week with multiple articles of everything that's going on in immigration. And if you're signed up for our newsletter, you will get that every week with all of those updates. So you can stay on top of what's going on in immigration, even if you are not able to tune into our weekly updates on Tuesdays.
And every day we do have a free Zoom call. We've been doing this from past, it used to be conference call, now it's a Zoom call. From past 13 years, every single day we have a half an hour. The timings are provided, the link there, you can participate in it. It's always good, once in a month or so to participate. It's more interactive, that one is. It's not like we read the questions and answer. It is going to be live interaction. You can participate in that, and the link is provided there at the bottom. Thank you very much for tuning.